Hey everybody, Christine here with Help Solve the Case with bronchitis. And I'm coming on to do the best that I can because we just had some information on the Luigi Mangione case in reference to a motion to suppress that was granted. And so very interesting when it comes to these cases, how police can do their job and what the judge ruled on. So I'm going to do my best to get through the original motion to suppress, and then we'll go through the order, okay? I may hack and cough, but I apologize. Okay, so this was filed, it looks like, I don't know, May 1st. I can't really tell the date. And this is Karen Agnifilio, the attorney, all right? And they're talking about, I haven't read this, so I'm reading through this with you. Talking about the indictment, the limited grand jury transcripts that have been disclosed to the defense, supporting papers, and discovery received thus far, and all proceedings herein. They're moving the court for the following order. So they want an order to suppress Mr. Mangione's statements to law enforcement, stating, this is their allegation, that officers failed to provide him with Miranda warnings in violation of his Fifth Amendment rights. And we'll get into these because I believe they're going to be enumerated below. Suppressing the evidence seized at the time of his arrest because law enforcement conducted a warrantless search of Mr. Mangione's backpack in violation of his Fourth Amendment rights after he was already handcuffed and surrounded by 10 police officers. And there's an important caveat to the warrantless exception. And then precluding the district attorney's office from eliciting lay non-eyewitness identification testimony at trial. Interesting. I don't know if that's Deseret. We'll see. Dismissing the indictment's terrorism-related counts 1 and 2, as the grand jury evidence failed to establish the required element that Mr. Mangione intended to intimidate or coerce a civilian population and influence the policies of a unit of government by intimidation or coercion, or affect the conduct of a unit of government by murder, assassination, or kidnapping. And 5, dismissing the indictment because concurrent state and federal prosecutions violate the double jeopardy clause, the 14th Amendment's due process clause, and Mr. Mangione's constitutional rights against self-incrimination to meaningfully defend himself to a fair and impartial jury and to the effective assistance of counsel, and granting other such relief as the court deems appropriate. So if they haven't enumerated everything, if the judge catches something, to please make an order. And they say, please take notice that he reserves the right to file additional motions that may be necessitated by additional discovery, because sometimes the judges will come in and preclude motions after a certain point, because some people will just what they call paper a case to death. Okay. I'm just looking out here. I don't know. We don't need, that's like the table of contents. We don't need that. Okay. All right. Yeah, this order just came out. So I got the order too. Okay. So Karen Agnifilo, however you pronounce her name, she's going to this background. She says she makes this affirmation in support of the motion April 30th. Okay, going back through those numbers again that we just outlined. She said this affirmation is based upon information and belief. And what she used to make the affirmation, the information and the beliefs that she has, was derived from the indictment, incomplete grand jury transcripts and exhibits, prior court proceedings, materials previously disclosed to the district attorney's office, and information disclosed in court by the district attorney's office and applicable legal authorities. Now, Luigi Mangione is, presumed innocent. These are all allegations, right? We have not gone through the court process. So I'm going to say this here, and then I don't have to repeat it, right? Okay, and I'm not an attorney. I'm a law enforcement expert. But this is not a formal legal opinion. If you would like a formal legal opinion on this case or any other case, please feel free to contact me. I'm just going over this based on my experience in law enforcement, longtime investigator, and working on these type of cases. And it's interesting. So, and people like to be educated about, all right? I've been in the court system for a very long time. Okay, I started 1986 in the court system, working as a paralegal. So, working for the public defender's office before I became a cop. So, I got all sides. All right, let's get to it. So, thanks for being here. I'm sorry if I sound like a barking seal, but I will do my best. So they're stating here 377 people were murdered in New York City in 2024. Only one, however, the December 4, 2024 shooting of United Healthcare CEO Brian Thompson, has led to a legal tug-of-war between state and federal prosecutors as they fight for who controls the fate of 26-year-old Luigi Mangione. So that's interesting, right? This is the defense attorney writing this. So it could be argued that they're saying why in this, out of 377 people who were murdered in New York City, why is it only this case that there's a tug of war between state and federal prosecutors? Why is that case special? Okay. It says, as a result of unprecedented strong language, strong language alert, strong legal language, as a result of unprecedented prosecutorial one-upmanship, and again, these are the defense attorney's words that are not mine. One-upmanship, Mr. Mangione now faces 3 simultaneous prosecutions in 3 different jurisdictions, one of which is seeking the death penalty, while the other is seeking life imprisonment. And that number 1 says that he's also facing forgery and gun possession charges in the Commonwealth of Pennsylvania. And she says it's all for one set of facts, right? So is that double jeopardy, right? She says, yet, despite the gravest of consequences for Mr. Mangione, right? Death, life imprisonment. She says law enforcement has methodically and purposely trampled his constitutional rights by interrogating him without Miranda warnings, in violation of the Fifth Amendment, and illegally searching his property without a warrant in violation of the Fourth Amendment. Okay, so they're talking about U.S. Constitution Amendments 4 and 5. Okay, and if you don't know, Fourth Amendment, search and seizure, allowing you to be safe and secure in your person and property, whatever. And Fifth Amendment, self-incrimination, Okay, so she continues. Compounding these constitutional violations, the district attorney's office has expanded New York's terrorism statute well beyond its legislative intent and its natural and legal definition to seek enhanced charges against Mr. Mangione, while also violating Mr. Mangione's rights against double jeopardy by simultaneously charging him alongside the federal government for identical alleged conduct. Critically, these concurrent prosecutions also violate due process and Mr. Mangione's constitutional rights to present a defense and not incriminate himself because of the state and federal prosecutions have conflicting theories, and Mr. Mangione's defense of one case could potentially be used against him in the other prosecution. So that's very important here, right? So again, I don't know. I mean, I know what happened, but I don't know the exact charges and exactly what's going on. I'm reading this for the first time here because the announcement came out, and I really like these precedents and to see how they're applying the Constitution and the law and what the cops did and all this stuff, right? We want to learn from all of this. And so what I'm thinking here potentially is that with the terrorism charges, right? A double jeopardy could be seen to apply for the same charge at the same time. But, terrorism is a different charge. So is that double jeopardy? But it's based on the same set of facts as she's saying. So the same incident, right? So it'd be the same evidence, the same facts. So if he decides to testify for himself, which we don't know, or they're filing pleadings in the case, making certain allegations that could be used against him, right? A lot of times, even pre-trial, through motions and hearings and different things, you get an idea of the other side's case. All right, so they're just saying it could hamper, all these different cases could hamper it because information is getting out and they're the same charges or they're arising from the same incident. So I think that's what she's saying here. All right, I got a cough drop, so hopefully it'll get a little better. Okay, so we were talking about the double jeopardy. So she says, as discussed below, concurrent state and federal prosecutions also violate Mr. Mangione's constitutional rights to a fair trial and impartial jury, because stuff could get out, and to the effective assistance of counsel. Finally, forcing Mr. Mangione to defend himself in the instant case will remove rights to afforded to him in the death penalty case. Okay, that's interesting. Not sure exactly what that is off the top of my head. She says, accordingly, Mr. Mangione requests that this court suppress his statements to law enforcement and the evidence illegally recovered without a warrant from his backpack. In addition, pursuant to People v. Mosley, 41 New York, citation, discussed below, the court should preclude the district attorney from eliciting lay non-eyewitness identification testimony at trial. It's interesting. Let's see what that is. Mr. Mangione also requests that this court dismiss counts 1 and 2 of the indictment that rely on New York's inapplicable terrorism statute and are not supported by the grand jury evidence. Interesting. Lastly, Mr. Mangione also requests that this court dismiss the indictment because concurrent state and federal prosecutions violate the double jeopardy and due process clauses and limit his constitutional rights against self-incrimination to meaningfully defend himself to a fair and impartial jury and to the effective assistance of counsel. In the alternative, if you won't do that, the court can ameliorate these constitutional concerns by staying this state case while Mr. Mangione literally fights for his life in federal court. So they're saying to stay it is to put it on hold, to delay it, okay? So here's our facts. Again, allegations. On December 4th, 2024 at 6:45 a.m., United Healthcare CEO Brian Thompson was shot outside the company's annual investor conference at the New York Hilton Midtown. Mr. Thompson, who had been subject to previous threats, died at a local hospital approximately 30 minutes later. And then they have a little footnote there that his wife said threats had been made. Following, checking for tissues. I'm checking for tissue detritus. Okay. Following the shooting, the NYPD released the video of the shooting and pictures of the masked suspect to the public. I remember seeing that. Within hours of the shooting, law enforcement also disseminated to the media and the public that 2 of the discharged shell casings had the words, quote, deny, end quote, and, quote, depose, end quote, inscribed on them. And that the word, quote, delay, end quote, was inscribed on a bullet recovered at the scene. Okay? And they got a footnote here. Law enforcement incorrectly initially reported to the media that the words inscribed on the bullets were deny, defend, depose. Okay. The NYPD began a nationwide manhunt to search for the mass perpetrator and also enlisted the help of the public by posting a reward for information leading to his capture. The NYPD viewed thousands of hours of surveillance video to attempt to locate the shooter and where the shooter had been in previous weeks. The NYPD police commissioner stated that she assigned 10 detectives from the NYPD's intelligence division to search through social media profiles of hundreds of young men who looked similar to the shooter and had also posted negative comments about the health insurance industry. So that's interesting. On the morning of December 9, 2024, Patrolman Joseph Detweiler, December 9th, hold on. Okay, so December 4th to December 9th, because timing is important in what the police do. On the morning of December 9th, Patrolman Joseph Detweiler and Tyler Fry of the Altoona Police Department responded to a McDonald's restaurant based on a 911 call of a, quote, suspicious male that looked like the shooter from New York City, end quote. And they're taking that from the grand jury transcript, which are secret. Arriving at the McDonald's, the patrolman, both in full uniform and displaying badges, approached Mr. Mangione at 9:29 a.m. This is what, 5 days later? As he sat at the back table in the back of the restaurant. As pictured below, Mr. Mangione was sitting at a corner table with a wall behind him and to his left. I'll look at that footnote in 1 second, okay? Okay, so he can't go this way, can't really go that way. Table's here. His escape route is, right, or if he's going to do harm to the officers, I'm just giving you my perspective, he's got to come here or come over the table, because safety is going to be important here in just a moment. Okay. Number 5, the still photos embedded in this motion are screenshots from the police body-worn camera. Okay. So there he is. This is at 9:29:12. Don't know what that is. I'm going to leave that up there so we can see it. Patrolman Detweiler and Fry position themselves to Mr. Mangione's right, blocking his only exit from the table. See, I'm not going to steer you guys wrong, okay? Blocking his exit as he was already surrounded by 2 walls and a table. I did not read this, I'm telling you, okay? Patrolman Detweiler first asked Mr. Mangione to pull down his face mask and then asked for his name. So they're doing a consensual stop here. Called well, you could even call it a contact. But they're asking him to pull his face mask down. Patrolman Detweiler told Mr. Mangione that someone had called the police because they thought he was suspicious. Okay, so now we're going to get into the cop's mind. They're on a suspicious person call. Both patrolmen were in uniform and fully armed. After Patrolman Detweiler asked to see Mr. Mangione's identification, Mr. Mangione is alleged to have provided a New Jersey license in the name of Mark Rosario. The patrolman asked Mr. Mangione if he was from New Jersey and whether he had been to New York recently. I'm trying to keep the picture up. As Mr. Mangione prepared to eat his food, Patrolman Detweiler moved even closer to Mr. Mangione. Now, where's Detweiler? We don't know. Who's where? We know they're over here. Okay, Patrolman Detweiler moved even closer to Mr. Mangione, asked him what he was doing in New York. Before Mr. Mangione even responded, Patrolman Detweiler asked him to stand up and put his hands on top of his head, with Detweiler grabbing and lifting Mr. Mangione's right wrist above his head. Sounds like a Terry stop or more to me. And Terry is let me pull that up. We just know it is Terry. It's Terry v. Ohio, if you want to look it up. Okay. So, Patrolman Detweiler asked Mr. Mangione why he was so nervous as Detweiler frisked Mr. Mangione. So that's a stop and frisk. Patrolman Detweiler ordered Mr. Mangione to sit back down at the table and directed Patrolman Fry to talk to Mr. Mangione while Detweiler motioned for Fry to move physically closer to Mangione to reinforce Mangione's inability to leave. And so it sounds like they're cornering him. I'm not sure. He put his wrist above his head. Okay, so then they let him go. They let him sit back down. He wasn't handcuffed. Okay. As Patrolman Fry effectively had Mr. Mangione in custody while he stood watch over him and blocked any potential exit, Patrolman Detweiler went outside to call another officer and tell him he was 100% sure that Mr. Mangione was the individual that law enforcement was looking for, connected to the December 4th, 2024 shooting in New York. So, a lot of things come into play here. And like I said, this is not a formal expert opinion, but things you might want to consider or ask or be thinking about. You have a custodial detention, right? You have a consensual contact. You have a stop and frisk, which is what they did. That's a little higher escalation. And then you have a detention. Okay. Now, with Patrolman Detweiler saying he was 100% sure that Mr. Mangione was the individual, sorry guys, that law enforcement was looking for, he had in his mind that he was arrested. Okay. So now we've gone from innocent, some random dude, to, hey, can I talk to you for a moment? To, hey, pull down your face mask. They're, isolating him, frisking, looking at the ID, and then he's telling him, get closer, like, do not let him leave. And then he's going out and saying, yep, it's him. So that sounds like, and probable cause, just probable cause. It doesn't have to be beyond reasonable doubt, right? So they're pretty certain, according to what we're reading. We're just reading this, right? That's what it sounds like. Again, no formal opinion. Okay. So, all right. So he was 100% sure. Detweiler returned to the back area of McDonald's to further interrogate. And that's her choice of words. Because Miranda applies with custody when you're not free to leave. And it's in the person's mind, right? The cop needs to know when that happens. But going back to the table, the wall, the cop, maybe, I don't know if the guy's standing here, one standing here. It's in the person's mind, okay? So, I'm assuming my language here, that the defense is thinking he's detained, or they're arguing he's detained, he's in custody, he's not free to leave, and Miranda applies, okay? So, asking if he was from New Jersey, now they said they already asked that, okay? So it could have been innocent. Now they're asking it again. Had he been to New York recently? Well, if he'd been to New York recently, that's another tick on the ladder towards, well, he looks like the guy and he was in New York, right? Ding, 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 ding. So, see, she says here, even though Patrolman Detweiler had already decided, okay, so they knew they were going to arrest him. So he's in custody. It doesn't, there's ways to do it. Let me just say, Miranda has been messed up good cases in a bad way. Like you really have to be, it's not hard to fulfill the obligation, but you have to be trained. Like, you have to know how to do it the right way in so many different situations. So an inexperienced person that doesn't approach an entire conversation, let me just say from a cop perspective, any conversation can go south very easily. So you have to be able to know how to communicate and stuff like that. Okay. So, but officers don't like it. They don't like Miranda because it can really mess cooperation up, right? And it probably should, right? If you look at it, and if you're guilty, if you think that you're guilty, we're talking in general, are you going to say anything? Should you say anything? Probably not. So somebody invoking, that's what they call invoking, the right to an attorney to remain silent, probably a good thing for them. So police don't like asking. But there's a way to do it. And that's not coercive or anything. There's just a way to do it. You got to read the scene, you got to read the situation, and you got to know when you need to do it, and you got to know how to do it. Okay. So she's saying that he had already decided that he was a shooter, right? He told, that was Detweiler again, as a pretext. That's another big police no word, okay? As a pretext for the police interaction, that they were there because Mr. Mangione had been at the McDonald's for 40 minutes. Oh no. I'm just throwing that out there because we didn't hear that. That would be uncovered in the 911 call. Okay. How many people, I don't know what New York's laws are, but how many people, let's just say he was homeless or he was how many people have an hour lunch hour or a 45-minute lunch hour? Granted, it's the morning, right? So breakfast. How long do you take to eat? Maybe you're reading the newspaper, you're reading your phone. Oh no. But the lawyer's saying pretext. Okay? So she would be able to determine if it's a pretext by seeing if the 911 call said that. And on the defense side, and I've done this in cases, you pull all the calls. Okay, you pull disparate treatment. You pull the calls to see if everybody that has been there for 40 minutes gets the police called on them. That shows you if it's a pretext or if it's preferential or disparate, what they call disparate treatment. And that data is available by FOIA, or the defense can subpoena all the McDonald's footage and document everybody that's been there over 40 minutes and see if they have the police called. That's what she's saying. Okay. So she's saying it's pretext. Then she says, Patrolman Fry remains in his strategic position, blocking his exit as Detweiler continued interrogating him. So let's see. What else did he say? Oh, there we go. Yep. So he's blocking him over there. I was looking to see what he's got here as far as stuff. Okay. At 9:41 a.m., 12 minutes after they first approached him, okay, that's definitely on detention. We don't know if this person, believed to be Mangione, asked to leave. Patrolman Detweiler moved a back plaque. 12 minutes. I know where this is going. Exigency. Wingspan. 12 minutes after they first approached Mr. Mangione, Patrolman Detweiler moved a black backpack from the floor where Patrolman Fry had been blocking Mr. Mangione's path to an area far out of Mr. Mangione's reach. In the next minute, The army came. The backup came. 5 additional uniformed and armed officers entered the back area of the McDonald's where Mr. Mangione was detained and in custody. Dun, dun, dun. We're watching it. Excuse me. Patrolman Detweiler ordered another officer to stand next to Patrolman Fry, forming an armed human wall, oh my goodness, trapping Mr. Mangione at the back of the restaurant. Again, attorney's words. As Detweiler walked outside to talk with other officers to confirm that Mr. Mangione fit the description of the New York suspect, I'd have been on the other side of the table, frankly, but okay. When Patrolman Detweiler re-entered the McDonald's at 9:45 a.m., oh, there were 3. Okay, good. Because that's an open area. When he re-entered, there were 3 patrolmen surrounding Mr. Mangione. Mr. Mangione's backpack was approximately 6 feet away on a table. Notably, 2 of the patrolmen were positioned between Mr. Mangione and, there you go, Mangione and the backpack. Oh, there, I think that's the backpack. Okay. Well, we'll get into it when we start talking about exigency. At 9:46 a.m., with 8 officers now on scene, okay, so I don't mean to laugh, but if Mangione didn't know that he has a potential problem by then, he probably knows now. Another officer asked Patrolman Detweiler if he had read, excuse me, Mr. Mangione, his rights as required by the Supreme Court's ruling in Miranda versus Arizona. And I don't think he asked the question that way. And it's important to know, like you just be like, have you read him yet? Okay, because you need to know what you can ask and what you can't. So, when Patrolman Detweiler responded that he had not, the officer told Detweiler to tell Mr. Mangione that he was under official police investigation and to read Mr. Mangione his rights. All on body-worn camera, it seems. Patrolman Detweiler informed Mr. Mangione that he was under official police investigation. That's interesting words, not detained and that he would be arrested for, quote, false ID, end quote, if he gave the police a false name again. Still, without reading Mr. Mangione his Miranda rights, Patrolman Detweiler continued interrogating, and interviewing and interrogating are 2 different words. Okay? How can I easily say that? Interviewing's like, what's your favorite thing? Do you like traveling? You know, like that sort of thing, where you don't know the answer, right? It's not a question. I mean, I was going to say it's not a question asked to elicit a response. It is in an interview question. You'll be like, hey, because you're keeping the conversation going. You're interviewing. But you don't have an expectation of the answer, okay? Interrogation, you do. Okay. Okay. All right. Still without reading Mr. Mangione, and this is attorney's allegations. Still without reading Mr. Mangione his Miranda rights, Patrolman Detweiler continued interrogating him by asking if his name was Mark Rosario. So if he's providing a false name to law enforcement and obstructing their investigation into the killing, the suspicious sitting at McDonald's, or whatever you want to call it, impersonating, false reports to law enforcement, whatever, okay? If it's attached to a crime, right, could be a problem. He said, he continued interrogating him by asking if his name was Mark Rosario, to which Mangione replied no. Detweiler asked for his real name and date of birth, which Mr. Mangione provided. Another officer at the scene asked Mr. Mangione twice why he lied about his name. At this time, there were 9 officers surrounding Mr. Mangione and blocking his exit from the McDonald's. Okay, So pretty simple here. If you're applying Miranda, the way the attorney's applying Miranda, not free to go, in custody, not free to go, could implicate yourself. Well, if you say, Mangione, right, could implicate him, right? Because Mangione could have been one of those people on the list or on social media that had made grudges or statements or the manifesto to I hate healthcare or whatever, right? So she continues. Now we're going to get into the search, I believe. At 9:48 a.m., nearly 20 minutes after law enforcement. It comes without warning, the tickle. At 9:48 a.m., nearly 20 minutes after law enforcement first approached Mr. Mangione, prevented him from leaving, and asked him numerous interrogation questions, Patrolman Stephen Fox finally read Mr. Mangione his Miranda warnings. After informing him of his constitutionally protected right to remain silent, Patrolman Fox asked Mr. Mangione if he wanted to talk to law enforcement. Mr. Mangione exercised his constitutional right to remain silent and expressed that he did not want to speak to law enforcement. Sorry, I just read the next sentence. Patrolman Fox told Mr. Mangione that he was, quote, not in custody at this point, end quote, despite the fact that at that moment there were 10 officers in the back of the McDonald's where Mr. Mangione was sitting. They had already decided with 100% certainty that he was the shooter and he was clearly in custody and not free to leave. Wow. Interesting. Patrolman Fox then asked Mr. Mangione why he had a fake ID. After Mr. Mangione did not answer, Patrolman Fox ordered Mr. Mangione to stand and put his hands on the wall so he could pat him down, to which Mangione complied in all respects with these directives. Was that another pat down or was that the rest pat down? At 9:50 a.m., approximately 90 seconds after telling Mr. Mangione that he was not in custody despite being surrounded by officers after he had been patted down twice, Patrolman Fox handcuffed Mr. Mangione and thoroughly searched him again. Mr. Mangione remained standing handcuffed and surrounded by officers as they waited for verification of his identification. Okay, so maybe he gave him, goodness, look at that. At 9:54 a.m., Patrolman Detweiler walked out of McDonald's to discuss Mr. Mangione's identification with another officer. During this conversation, and without any explanation, Patrolman Detweiler covered his body-worn camera with his hand to prevent the camera from recording 20 seconds of his conversation. Yeah. And there's policies and whatever, and we'll leave that there. At 9:58 a.m., several officers began searching through Mr. Mangione's jacket and pockets and frisked him again. At the same time, Patrolwoman Christy Wasser and Patrolman Fox began searching through the backpack law enforcement had placed on a table out of Mr. Mangione's reach more than 17 minutes earlier. So, in your person, right? So, the Terry stop that we talked about. And I'm just giving in general. I'm not talking about this case, but I'm just giving in general, and this is not a formal opinion. But a Terry stop is to, for safety, make sure you're okay. It's not, it moves up from a consensual encounter, okay? Make sure you're okay. Hey, man, you got any weapons on you? Blah, 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 blah. Okay, you're good. They did that. Okay, they did that. And we did not see that backpack anywhere right near him. Okay? So now you have search incident to arrest, okay? And destruction of evidence and things they call, you can't see my arms, wingspan, put your arms out. Immediate span of control, okay? So wherever that backpack was on the floor, could he have reached it to get a weapon, to destroy evidence, or do anything like that? We don't see that. And it was put on a table. And she's saying it was put on the table out of reach more than 17 minutes earlier. So she's arguing it needs a search warrant, okay? And we're going to see what happened when we look at the order, okay? So so we don't have exigency, destruction of evidence. He can't get to it. He's got all these people, okay? He ain't getting over here, right? And we don't know where that came from. Can't see it here. Maybe I'm more at the body cam. Okay. Okay, so they begin searching through the backpack. As part of these warrantless searches, Patrolman Wasser opened Mr. Mangione's backpack and fully searched the backpack, its compartments and its contents, including closed bags that were within the backpack, while Mr. Mangione stood handcuffed and surrounded by officers who were positioned between Mr. Mangione and his backpack. Now, there's a difference, and I see this all the time, between an inventory search in preparation for the arrest, which is for itemization and documentation, which many times can include in the standing operating procedures in the police department, the direction or the order that you must go into all the containers or whatever, okay? And I've seen where they swap for incident to arrest inventory, okay? So that's what she's saying, okay? So he was handcuffed, surrounded by officers, okay? Excuse me. So here he is, and they're going through the backpack. As part of this warrantless search, Patrolman Fox retrieved a small item from inside the backpack that was enclosed in cardboard and wrapped in tape. So we can infer from that, just in her description, it's not visible. On plain view, let's just say they have a right to go in there and they can see what they can see. Well, it's in cardboard and it's wrapped in tape. So does it look like a gun? Does it look like cocaine? Does it look dangerous? Does it look right? Patrolman Fox took out his knife and sliced open the tape to find a computer chip inside. The officers continued their warrantless search, again, this is her language, through Mr. Mangione's backpack at McDonald's, even after he was removed from the restaurant by other officers and driven to the precinct. Okay, so is it inventory to arrest? It's not even going with him. During this continued search at McDonald's, Patrolwoman Wasser recovered a gun magazine loaded with bullets. Now realizing she had made a potentially devastating mistake by thoroughly searching the backpack of a murder suspect in a significant New York press case without a warrant, she suddenly stated that she was searching through the backpack at McDonald's to make sure there, quote, wasn't a bomb or anything in there, end quote, before putting the backpack in the car. Exigency, right? A bomb would be exigency versus inventory. And this attorney, the falsity of that comment was made clear seconds later when another officer at McDonald's stated, quote, now that we found that, she says, i.e. the loaded magazine, let's just bring it back, end quote, to the precinct. Suddenly, not concerned about a, quote, bomb, Patrolman Wasser placed all the items back into the backpack and stopped searching. Okay, let's just talk about a bomb in the briefcase, or in the backpack. A bomb would be kind of visible, right? Like, let's just say, I don't know, he didn't have a bomb, did he? I don't know. The original one, he shot. He didn't have a bomb, or allegedly have a bomb. The person that shot the healthcare guy, not Mr. Mangione, he's assumed innocent, but the person that the suspect that shot the healthcare guy didn't bomb him, right? So it sounds like Officer Wasser would be like New York, bombs in backpacks, like, right? So that's exigency. Let's just make sure there's not a bomb in here that's going to hurt us and everybody else, okay? All right. Which is different than, to me, taking a knife and cutting open a thing in cardboard. Patrolman Wasser repeated her comment that she was making sure there were no bombs in the backpack, as another officer commented that, quote, "At this point, we probably need a search warrant for it," end quote. Without calling for the bomb squad, evacuating the McDonald's, or even searching for a bomb, Patrolman Woman Wasser placed the backpack in her police car and brought it to the precinct. She left the McDonald's at 10:04 a.m., and there's no body-worn camera footage for her for the next 11 minutes as she drives to the precinct with the backpack. Again, they want to make sure it's not being tampered with. Because now it appears she found bullets in there, right? She found rounds. Loaded magazine. Okay? That's evidence. Chain of custody, tampering, and all that stuff. So they're saying maybe you don't want to put a camera on it. But in the dinosaur days, we didn't have those cameras, so they had to take our word for it. Okay. There's no body-worn footage from her for the next 11 minutes as she drives to the precinct with the backpack. At 10:16 a.m., 1 minute after arriving at the precinct, she continued her warrantless search of the backpack. She reopened the same backpack compartment that she had started searching at the McDonald's before immediately closing that compartment and opening the front compartment of the backpack as if she was specifically looking for something. Instantly, she, quote, found, end quote, a handgun in the front compartment. After finding the gun at the precinct, Patrolman Wasser again explained to another officer that she quickly searched the bag at McDonald's to make sure that there were, quote, no bombs or anything, end quote. Patrolman Woman Wasser did not explain why she did not seek a warrant once she had arrived at the precinct. Patrolwoman Wasser continued to search the backpack at the precinct without a warrant and recovered a silencer, a red notebook containing Mr. Mangione's personal writings, additional writings, a computer chip, an iPhone, and several USB flash drives. Over 7 hours after the warrantless search of Mr. Mangione's backpack, the Altoona Police Department finally sought a search warrant at 5:14 p.m. This warrant application sought permission to search and seize the items from Mr. Mangione's backpack that law enforcement had already searched several times and seized earlier that morning. That would be cool to read. Okay. Mr. Mangione was formally arrested and charged in Altoona with forgery, could be maybe the license, I'm not sure, possession of a weapon, and tampering with records or identification, possession of an instrument of a crime for possessing a silencer, and furnishing a false identification to a law enforcement officer. Excuse me. On December 17, 2024, the New York County District Attorney's Office publicly announced that Mr. Mangione had been charged by a grand jury in an 11-count indictment alleging the following crimes. Terrorism, murder second degree, murder first degree, criminal possession of weapon, I don't know what all that is, forged instrument. 2 of these charges, murder in the first degree, count 1, and murder in the second degree as a crime of terrorism. Okay. Rely on the terrorism statute. Because just one person died. So they must add it as another count or something, a subsection. During a press conference by the Manhattan District Attorney and the NYPD Police Commissioner announcing these charges, There was no mention whatsoever of federal case. Now she's back to her double jeopardy. On December 19, 2024, after waiving extradition to New York, Mr. Mangione was transported via procession in a fleet of over a dozen police cars, and then was flown via plane and helicopter to New York from Pennsylvania. Upon arrival, Mr. Mangione was paraded in a choreographed, highly publicized perp walk, end quote, by the NYPD, the FBI, and New York City mayor. Later that morning, hopefully that didn't blow your ears out, sorry. Counsel was on the way to this court for a previously arranged afternoon Supreme Court arraignment at 2 p.m. Before Mr. Mangione could be brought to this court for his planned state court arraignment, the FBI unexpectedly seized custody of Mr. Mangione and brought him to the Southern District of New York, where he was charged by federal complaint filed the night before, charging him with stalking 2 counts, murder through use of firearm, and a firearms offense. These charges are based on the same facts and evidence as the New York State indictment. Mr. Mangione was remanded to federal custody at the Metropolitan Detention Center in Brooklyn, where he's currently still detained. On December 23, 2024, Mr. Mangione was produced to this court and was arraigned on the pending indictment. To date, the District Attorney's Office has produced more than a terabyte of information. And she's alleging, notably, the District Attorney's Office has withheld additional discoverable materials, including portions of the grand jury testimony. How can you defend your case when you don't know what they're saying against you? On April 1st, 2025, the United States Attorney General directed the Southern District of New York prosecutors to seek the death penalty. On April 17, 2025, the federal prosecutors formally indicted Mr. Mangione for the charges listed in the federal complaint. On April 24, 2025, federal prosecutors filed their notice of intent to seek the death penalty. And on April 25th, 2025, Mr. Mangione was arraigned in federal court. So, they're going to argue the law here about Miranda. They're asking that all the evidence has to be suppressed because they did not obtain a search warrant. And let's just talk about warrantless searches in New York. Altoona law enforcement failed to follow fundamental Fourth Amendment. I don't know why it says New York. Failed to follow fundamental Fourth Amendment case law and basic police procedure, right? That's what I specialize in, by failing to obtain a search warrant before searching through Mr. Mangione's backpack and the closed containers within the backpack, right? If you want to think about it, and not talking about his thing, but just in general, if you're doing a cursory search for weapons, right? Like, have you ever gone to a football game or whatever? You're not supposed to have a bag and you have to go, or a concert, and you go through the screener and they look at it and, you've got stuff in there, but they're just looking for big stuff. They're not, going in the zippered pouches and pulling out your nail file or your lipstick or whatever you have in your purse or bag or whatever, right? They're just like, is there anything bad that he or she or you or whatever could quickly grab and hurt anybody or destroy evidence, eat some drugs or flush some drugs or whatever. So police so it's not in the containers, the closed containers, right? Police conducted this warrantless search even though there were no exigent circumstances, as Mr. Mangione was already in handcuffs. The backpack was on the table over 6 feet away, and Mr. Mangione was separated from this table by a wall of armed officers. As confirmed by body-worn camera footage, the entire search of the backpack was done after it was secured and moved far from Mr. Mangione's grabbable area. That's that wingspan. Okay, it's called wingspan. Okay. Trying to see where this number is coming from, the 6. Okay. Then she says the Fourth Amendment protects individuals from unreasonable searches and seizures by the government. And it says, they're talking about a New York case here. The New York Court of Appeals has said that all warrantless searches are unreasonable. Okay? You have to have a search warrant. Period. Like, just believe, when I say, you guys have heard me say, all deaths are homicide until proven differently. That's it. You just have to think, all traffic stops are not routine. Like, you walk up on that car as a cop and you think like, I'm going to get killed. Like you have to prepare yourself that there is danger in that car. It's just the way you have to do it. And so you don't search nothing unless you have a warrant. Like, that's your mindset. You have to be like, can't touch it. Can't touch it unless you get consent. Hey, can I look in your backpack? They didn't ask him. Hey, can I look in your backpack? Right? I used to ask all the time, hey, can I search your car? Find all kinds of drugs. like, just ask, okay? So that's the mindset. Like, no. Just say no, okay? But then you have the exigency. Like, could anybody grab anything, or could there, like the officer said, be a bomb in there? God forbid. But that should probably be like immediate, right? Like the Terry stop, the pat down is like, hey, hold on a second. He'd be like, hey, look in there. Okay, no bomb. We're good. Okay. But again, we're just talking in general. Okay. So they're all unreasonable per se, and where a warrant has not been obtained, it's the people who have the burden of overcoming this presumption of unreasonableness. It's a burden is on the state. The state are the people. She continues, while New York courts have accepted, this is what I talked about, a search conducted by law enforcement incident to a lawful arrest, quote, as an exception to the warrant requirement, the prosecutors must first satisfy two separate requirements. Quote, the first imposes spatial and temporal time limitations to ensure that the search is not significantly divorced in time or place from the arrest. The second and equally important pillar predicate requires the people, the state, to determine the presence of exigent circumstances, end quote. So that's, like I said, walking up and just like you're patting him down quick, you're looking in the bag quick. You're not 20 minutes later, right? 20 minutes later is, hey, can I look in your bag? And then if they say no, you get a warrant, okay? But we're just talking in general, okay? So they have to show exigency. And what's her name? The lady said something about the bomb, but they weren't investigating a bomb threat, right? They were investigating, allegedly, somebody that sat for over 40 minutes in the restaurant. If that's true, the call, right? We've heard that the call, with the lawyer saying, we've heard that the call was, I think it's the dude. And then maybe he's been here for 40 minutes. Okay, we don't know, because we haven't heard the call. Okay, so then here we go about containers, right? The exigent circumstances requirement for searches incident to a lawful arrest specifically applies when law enforcement searches closed containers. In Jimenez, that's another precedent. The people bear the burden of demonstrating the presence of exigent circumstances in order to invoke this exception. Meaning, like, you better tell me how there's an immediate threat by a mince tin or something, right? So the person has to be able to grab the mince tin, and then there has to be what's in there. When addressing the exigency requirement for a warrantless search incident to a lawful arrest of property within the defendant's immediate control or grabbable area, the Court of Appeals has recognized two interests that may justify the warrantless search of that property incident to a lawful arrest. The safety of the public, which we talked about, and the arresting officer, and the protection of evidence from destruction or concealment. Okay? 20 minutes later, So she says, and here's something, People versus Julio. A bag that was in the immediate control or grabbable area of a suspect at the time of his arrest may not be subjected to a warrantless search incident to arrest unless the circumstances leading to the arrest support a reasonable belief that the suspect may gain possession of a weapon or be able to destroy evidence. So you have to know that there's a weapon, like when the lady said about the bomb. That's a good example. If you're going on a bomb threat call and you got a guy in a backpack, you could think, like, is there a bomb in there? Okay. Or, somebody's dealing drugs or whatever, or somebody had a gun or whatever. You can't see into the backpack. So it's quick, like the Terry pat down. It's quick. Has to be quick. Okay. She says, nevertheless, because the search incident to lawful arrest exception to the warrant rule requires exigency, means speed, it must be urgent, like a fire is burning down that house. You better get in there. Okay. Says a container may not be searched for a weapon or evidence if it is apparent, going back to that tape, I think we're going. If it's apparent that it is so securely fastened that the person arrested cannot quickly reach its contents, or the person arrested makes unmistakably clear that he will not seek to reach the contents, or the container is so small that it cannot contain a weapon or evidence of the crime. Mint tin. But remember, that little cardboardy square thing was all taped up. I mean, I'm assuming, I don't know, that they had a disc on there. Probably could have had something. I don't know, right? But it's wrapped up in tape. If the cop couldn't get into it without using his knife, right? These are the things that you have to look at, okay? So then she says, similarly, even a bag within the immediate control or grabbable area of a suspect at the time of arrest may not be subject to a warrantless search incident to arrest unless the circumstances leading to this arrest support a reasonable belief that the suspect may gain possession of a weapon or be able to destroy evidence located in the bag. Did I read that again? I don't know. I feel like I read that again, but okay. So she comes down here, she says, okay, that's Jimenez. She's just outlining Jimenez there, I think. She says, moreover, a search incident to a lawful arrest is not justified and suppression is proper when the defendant's backpack is, quote, not within the defendant's immediate control or grabbable area at the time he was arrested, end quote. She says, the defendant was handcuffed at the time of the search and it was no longer in his control. Okay, let's see. She's citing all these court things here. Okay, she's citing Morales here because she says it's a call inside a restaurant. She's picking and choosing things that she feel, not picking and choosing valid court cases and court decisions that she thinks would help. No, she's talking about suppressing the evidence here. The search of a jacket was justified because the jacket may have contained a loaded gun that would endanger the police and the public. Yeah, because all you have to do is put your hand in the pocket. So then she says there's no exigent circumstances. She says there can be no disagreement that at the time law enforcement started searching Mr. Mangione's backpack, he was in handcuffs and surrounded by police officers while the bag was approximately 6 feet from him. Moreover, even before Mr. Mangione's arrest, the backpack was not in his immediate control or grabbable area because Patrolman Detweiler had quickly moved it to another table approximately 6 feet away 9 minutes earlier, and there was a human wall of police officers strategically standing between Mr. Mangione and the backpack. In addition, even before the arrest, the scene was police controlled as there were 10 or more officers in the back of McDonald's. Nevertheless, despite the lack of any exigency, officers began searching through his backpack while in McDonald's. There was certainly no exigency time and wingspan. Once he was removed from the McDonald's, she says yet they continued to search it at the restaurant without a warrant. She says it's illegal. She says the fact that they believed that he was the person wanted for murder does not change the analysis or provide necessary exigency because the shooting happened 5 days earlier. Remember, we talked about that. And the police had no reason to believe that the alleged shooter was still armed, right? It wasn't like somebody, and we don't, he's alleged, whoever did that in New York, was not shooting in all day, every day, right? So it wasn't a continuous scheme of things. That might be a little different, right? They said, even if they believed that the person might still be armed, any exigency disappeared after Patrolman Detweiler frisked Mr. Mangione for weapons, moved the bag away, and had armed officers strategically placed between Mr. Mangione and the backpack, right? So then she says there was no exigency once he was removed from McDonald's or once Patrolman Wasser brought it back to the precinct. While Patrolman Wasser claimed that she was searching the backpack to make sure there was no bomb inside, this post hoc excuse did not reflect any legitimate exigency. First, nothing about the shooting in New York or law enforcement's interactions. Sorry, it just comes on me. Ever had that where you get that tickle in your throat and then it's like terrible? Law enforcement's interactions with Mr. Mangione and the McDonald's provided a reasonable basis to believe that there was a bomb in the backpack. Second, the patrolwoman did not make this claim until after she had already been searching through the backpack and recovered a loaded magazine. Tellingly, writes the attorney, she stopped searching the backpack at the McDonald's when she recovered the loaded magazine. If one were legitimately concerned about a bomb, one would have either continued searching right then and there or cleared the McDonald's and have called in and waited for the bomb squad to arrive before searching the bag, neither of which occurred. That's a good point, right? Bring the bomb robot or whatever, bomb dog. She says certainly one would not have continued searching a bag in a McDonald's filled with officers, employees, and customers, or put the bag in their car to transport the potential bomb to the precinct. Now, I have to give you a little story here. When I first started, I heard a story about somebody bringing a bomb or a ordnance, unspent, unexploded ordnance to the police department. And like, you heard that over and over again. Don't bring anything bad to the police department, ever. Okay? Like, leave it. Do not ever, ever, ever. Okay? Sorry. That just reminded me of that. Yeah. She says, nobody would have put the bag in their car if they thought there was a bomb in there. Third, the officer sliced open the small taped up cardboard container, too small to house a bomb. And then she says this police theory claims exigency and without more would render all high-profile murder cases exigent by this standard, as there is always the theoretical possibility of a bomb inside a closed backpack. Good thought. Okay, so then she says, rather, all these circumstances demonstrate that Patrolman Wasser did not search the bag because she reasonably thought there might be a bomb. Rather, this was an excuse designed to cover up an illegal warrantless search of the backpack. This made-up bomb claim further shows that even she believed at the time that there were constitutional issues with her search, forcing her to attempt to salvage this debacle by making this spurious claim. Okay, let's see how bad, when we get to the order, let's see how bad this fruit of the poisonous tree is going to be. Because I don't know what was in the backpack. She says, nor can this search be justified as an inventory search. Remember, we talked about that. As the Court of Appeals has noted, an inventory search is exactly what its name suggests, a search designed to properly catalog the contents of the item searched. People versus Johnson. Here, the officers were not inventorying or cataloging the items of the backpack at McDonald's. That is clear from the fact that the officers did not write down what they were removing from the backpack, coupled with the fact that the officers put the loaded gun magazine back in the backpack once they found it and stopped searching altogether. And it says, music to my ear, It can hardly be said that an officer in this case followed the policy for inventory search by conducting a search that included only the glove compartment upon finding a gun, leaving it in place. That's People versus Johnson. Okay, so again, not a professional opinion. We're just chatting about things we find interesting. What the officers were doing instead was rummaging through the backpack looking for evidence. What do you think, audience? Such conduct is not a proper inventory search and is prohibited by the Supreme Court and New York. Florida versus Wells. An inventory search must not be a ruse for general rummaging in order to discover incriminating evidence. The policy or practice governing inventory searches should be designed to produce an inventory. It's another thing you're trained in the academy. The individual police officer must not be allowed so much latitude that inventory searches are turned into a, quote, purposeful and general means of discovering evidence of a crime. General rummaging. No general rummaging. Because the officers had no basis for their warrantless search, the recovered evidence must be suppressed. Okay, now she's going to say that here's the fruit of the poisonous tree, people. The illegally obtained evidence recovered from Mr. Mangione's backpack is not admissible under the doctrine of inevitable discovery. Okay, so we talked about this. I forget what other case it was. If you've watched my other videos, that if they're going to find it, it was Koberger. If they're going to find it anyway, if they would have inevitably stumbled upon it in their investigation, it's going to come in. But if they wouldn't, it's fruit of the poisonous tree. So let's see what she's going to say here. As the warrantless search was illegal, that's her words, the district attorney has no basis to claim that the recovered evidence should nevertheless not be suppressed because the evidence would have been inevitably discovered when the police conducted an inventory search of the backpack. In New York, the Court of Appeals has established that the doctrine of inevitable discovery does not apply, quote, where, as here, the evidence sought to be suppressed is the very evidence obtained in the illegal search, end quote. Because, let me think that through. Permitting its admission in evidence affects what amounts to an after-the-fact purging of the initial wrongful conduct, and it can never be claimed that a lapse of time or the occurrence of intervening events has attenuated the connection between the evidence ultimately acquired and initial misconduct. The illegal conduct and the seizure of the evidence are one and the same. So, I'm not the lawyer, but it sounds like what New York is saying, that, which is good, that if the bad things were found in there and you were looking improperly, and they might have found the bad things anyway, the bad things are going to go because it was improper. So I'm thinking it would have to be some unrelated material or something. That's good. The Court of Appeals further noted that admitting a legally obtained evidence through the inevitable discovery rule quote, what would amount to a post hoc rationalization of the initial wrong, end quote, would be an unacceptable dilution of the exclusionary rule, end quote, and, quote, would defeat a primary purpose of that rule, deterrence of police misconduct, end quote. Yeah. Additionally, failing to exclude wrongfully obtained primary evidence would encourage unlawful searches in the hope that probable cause would be developed after the fact. Yes. Yes. That's why we always look at when were reports written. When were reports written? Was it contemporaneous? I'm going to do a video if I can, once I get done with this, if I can continue to talk. But I was going to do a video today about probable cause. Because there was something in my mind about the Carmelo Anthony case, and I was going to do a video about that. And then this decision came out, and I was like, oh, I got to hop on that. So it's called creative writing. Okay. I don't know how much further we have. Let me see. We got a long way to go, but I think she's just going to argue it. Okay. She says, consequently, the doctrine of inevitable discovery is inapplicable to primary evidence. There's no basis. He has standing. Okay, so standing means he can argue it because it's his backpack. Okay. The district attorney's office should be precluded from eliciting lay non-witness identification testimony at trial. This is interesting. The district attorney's office has notified counsel it intends to offer 3 law enforcement witnesses at trial to make an in-court identification of Mr. Mangione. Interesting. Okay, Diaz, Detweiler, and Fry. And it will be grounded on a quote, an identification of the defendant from video surveillance, based on said individual's familiarity with the defendant, end quote. I've always thought about doing a Deseret hearing on officers. Interesting. District Attorney's Office cites People versus Coleman in support of its proposed in-court identification by law enforcement witnesses. The prosecutor's reliance on this case is misplaced. However, as the Coleman court ruled that the lower court erred in admitting testimony from 2 police officers and the defendant's aunt to establish that the defendant was the individual depicted on surveillance video of the alleged incident. That's interesting. Sorry, my mind is wandering. My mind is wandering to another case. Okay. Okay, so they're arguing Coleman. They're talking here about number 9. Interesting. So it looks like they're calling Sergeant Michael Horan. Oh, do I know him? No, different name. Okay, sorry. From the San Francisco Police Department, who contacted the FBI after observing a resemblance between the suspect from the New York City incident and the photos on Mr. Mangione's social media. Look at that. Look at that. He was still working. Like he's working. He's working cases in New York. Look at that. I like that. He's recognized for identifying high profile murders. I love that. Okay. So talking about that there. Now they're saying that while a lay witness may offer an opinion about the identity of a person captured in a photograph or video tape to aid the jury in cases where the witness is more likely to correctly identify the person than is the jury, such testimony is most commonly allowed in cases where the defendant has changed his or her appearance since being photographed or taped and the witness knew the defendant before that change of appearance. Because the prosecutors never claimed the defendant altered his appearance, there were no other circumstances suggesting that the jury, Okay, so the New York Court of Appeals ruled that the trial court erred in admitting a police officer's testimony. This case concerns an increasingly prevalent issue, which means since they're continuing to do it. When may someone who is not an eyewitness to a crime, oh, I got it, okay, testify to a jury that the defendant is the person depicted in a photo video? Okay. We hold that such testimony may be admitted where the witness is sufficiently familiar with the defendant that their testimony would be reliable, okay, like a relative or something, all right? And there is reason to believe the jury might require such assistance in making its independent assessment. Here, there was no showing that the proffered witness was sufficiently familiar with the defendant to render the testimony helpful. Okay. So she's saying Mr. Mangione's case demands the same result. Okay, so these officers were not involved in the crime. Nothing about altering his appearance. And they're conducting a Mosley hearing. Okay, we call it a Deseret, but they're calling it a Mosley hearing. Okay. And then they talk about the terrorism charge. Which I don't want to read the whole thing. Okay, and I guess the grand jury evidence, they're saying something that it failed to establish he intended to intimidate or coerce a civilian population. The only reference to a civilian population in the grand jury is the testimony of a United Healthcare employee who referred to United Healthcare employee as civilians. Oh, as an initial matter, the term civilian population, I don't know what that's really saying. So it was an employee. Because it was an employee, is that what they're saying? Because it was an employee, it wasn't like the general public? Yeah, I think that's what she's arguing. He's talking about his writings. This arguing over this civilian versus the employees. They also said that his writings were never released. So he couldn't be coercing or intimidating these people with his writings. Talking about a manifesto. They're going into his notebook. Furthermore, the extent district attorney seeks to support the terrorism-related charge by arguing that Mr. Mangione allegedly inscribed the words deny, delay, and depose on bullets. These facts do not demonstrate that Mr. Mangione intended to intimidate or coerce United Healthcare employees, the only civilian population referenced in the grand jury, or anyone else for that matter. Notably, law enforcement announced that these words were inscribed on the bullets, not Mr. Mangione. If Mr. Mangione intended to intimidate or coerce the civilian population, he would have publicly disseminated that he had written those words on the bullet, but he never did. So I guess they're saying there's no threat because it wasn't published. They do say it's worth noting what this case would have looked like without law enforcement purposely leaking information to the press and media. This would have been an alleged murder of a man outside of a hotel. Instead, the police leaked what was written on the bullets. The police leaked his writings, and the police called these alleged writings a manifesto, a term synonymous with terrorism. None of this was done by Mr. Mangione. It was law enforcement that created the air of terrorism surrounding this alleged crime, and who now seek to blame Mr. Mangione for the hysteria and fear they created. They're still talking about this civilian population, whatever it must be, to hit that terrorism statute. Okay, they're doing the federal charges with the state charges. I don't want to go too long. I mean, we've been an hour and a half. Double jeopardy. His inability to meaningfully defend himself is made more serious by the fact that the United States has directed the prosecutors in the Southern District of New York to seek the death penalty, while the DA's office is seeking life imprisonment. Allowing the state prosecution to proceed to trial first would violate Mr. Mangione's constitutional right to defend himself. And would force him to choose between the Scylla of life imprisonment and the whatever, Caribidis. I was thinking, interesting. I would think it would be the other way, but okay. Third, should he be convicted in the first highly publicized state prosecution? He couldn't find a fair and impartial jury. Yes. Fourth, concurrent prosecution, his right to counsel. Because trying to do all this at the same time, I think is what they're saying. Some other case. Mitigation. They're talking about mitigation. Mitigation investigating times consuming. Because of the tremendous amount of work and effort required to defend a death penalty case, as well as the more complicated legal issues involved, takes several years from indictment to trial in a capital case. I think they're talking about postponing it. These constitutional issues described above arise if Mr. Mangione is forced to proceed first with a state trial. Justice and common sense therefore dictate that the federal case with the more serious penalty of death should proceed first. That is what often occurs in the analogous situation where a defendant is faced both criminal and civil proceedings at the same time. Blah, blah, blah. They're talking about motion schedules and then the conclusion. So that's what they asked for. That's what they argued. These are Agnifilo, Kaplan. Wonder if they're married. That's what they argued. So I'm gonna put this, and then I'm gonna go to the order. See you guys later. Thanks for listening, and thanks for supporting, and we're gonna keep going.